Picture this. A sitting member of the British Parliament types their own name into an AI image generator, and what comes back isn't a photo. It's something that never happened, something fabricated, something they'd never say or do. Now here's the part that should stop you cold. When they asked who's legally responsible for that fake image, nobody actually knew the answer. Not the courts, not the lawyers, not even the company that built the machine. That's the situation playing out right now in the United Kingdom. A British MP has launched a lawsuit against xAI, Elon Musk's artificial intelligence company, the one behind the chatbot called Grok, and the goal isn't really money. The goal is a single, enormous question that no court on earth has properly answered yet. If an AI generates a damaging, false image of a real person, is the company that made the AI legally on the hook? Or do they get to shrug and say the machine did it? Think about that for a second. We've spent 2 years marveling at what these tools can create. Almost nobody stopped to ask who pays when they create something harmful. This one lawsuit could set the rule for every AI image tool on the planet, from Grok to the apps already sitting on your phone. And the way British law works, the answer might surprise absolutely everyone. So let's break down exactly what happened, and why this is so much bigger than one politician's reputation. So how did we even get here? Let's rewind. xAI is the artificial intelligence company Elon Musk launched back in 2023, and its flagship product is Grok, a chatbot built right into the social platform X, formerly Twitter. Now, most AI image generators are wrapped in heavy guardrails. Ask one of the big players to make a fake image of a real politician, and it politely refuses. Grok took a different road from the start. It was marketed as the rebellious, anti-establishment alternative, fewer filters, edgier answers, and crucially, an image generator that would happily produce things its rivals wouldn't touch. For a while, that was the selling point. Users could generate pictures of real public figures doing almost anything. It felt like a novelty. Then reality showed up. When you let a machine paint convincing images of real people with barely any limits. You don't just get jokes, you get fabricated scenes that look real enough to fool a casual viewer scrolling at speed. And public figures, politicians especially, became the obvious targets. The British MP at the center of this case says images of them crossed a line, false, damaging, and spread to an audience of millions. They went looking for accountability, and that's when they hit a wall. Existing law was written for a world where a human posts content, not where a machine generates it on demand. The rulebook simply doesn't fit. So instead of waiting for politicians to catch up, this MP decided to force the question through the courts. And what they are asking is deceptively simple. Here's the actual legal puzzle, and it's a beauty. For decades, the internet has run on one foundational idea: the platform isn't responsible for what its users post. In the United States, it's called Section 230, the law that says if you tweet something defamatory, you're liable, not the website. That single principle is why social media exists in the form we know it. Companies act like a notice board. They hold the pins, but they didn't write the notes. Now apply that to Grok and watch it fall apart. Because when you ask Grok to generate an image, there's no other user. There's no third party who created the content. The machine made it. The company's own software produced the pixels, so the old shield, we just host what others make, suddenly has nothing to hide behind. That's the trap this lawsuit is trying to spring. The MP's lawyers are essentially arguing that an AI company isn't a passive notice board at all. It's more like a factory, and if a factory ships a defective product that hurts someone, the factory is liable. That's basic product law going back a century. Think of it like this. If a vending machine dispenses poisoned food, you don't sue the snack. You sue the company that built and stocked the machine. xAI, naturally, would prefer to be seen as the notice board, not the factory. The entire case hinges on which metaphor the court accepts. And here's the twist nobody expected. The United Kingdom never had a Section 230 in the first place. Let's make this concrete, because abstract law gets slippery fast. We've already seen what happens when AI image tools meet real people, and it isn't pretty. Last year, fabricated explicit images of one of the world's most famous pop stars flooded X, racking up tens of millions of views before they were pulled down. The platform had to temporarily block searches for her name entirely. Then there were the fake images of politicians during election season, candidates shown at events they never attended, shaking hands with people they'd never met. staged to swing voters. In one widely shared case, an AI-generated image of an explosion near a government building briefly moved financial markets before anyone confirmed it was fake. A single fabricated picture, and real money evaporated. Now bring it back to our British MP. They're not a global celebrity with a legal team on speed dial. They're an elected official who found false images of themselves circulating to a potential audience of hundreds of millions on X. Reporting the individual posts is like bailing out a boat with a teaspoon. Take one down, the tool generates 10 more. That's the brutal maths of AI-generated content. The harm scales instantly, but the cleanup crawls. And here's the kicker: instead of chasing every single image, they're going after the source, the company that built the generator. Cut the problem off at the tap rather than mopping the floor forever. Whether the law lets them do that is exactly what's about to be decided. Now let's zoom out, because the United Kingdom isn't choosing this fight by accident. Compare the legal landscapes for a second. In America, Section 230 acts like a force field around tech companies. Courts there have repeatedly thrown out cases against platforms by pointing to those famous 26 words written back in 1996. It's the single biggest reason American AI firms feel relatively bulletproof. But Britain never built that force field. Under UK law, the rules around defamation and harmful content are far less forgiving to the people running the machine. There's also the Online Safety Act, a sweeping piece of British legislation that already puts legal duties on platforms to protect users from illegal and harmful material. So an MP suing in London is fighting on dramatically friendlier turf than they'd ever find in a Californian courtroom. And the contrast goes further. The European Union has its AI Act, which classifies certain AI systems by risk and demands transparency. Different tools, same direction of travel. The rest of the world is steadily deciding that AI companies can't just wash their hands. The United States is increasingly the outlier, the one place where the old shield still mostly holds. So this case is really a test of two philosophies. One says innovation needs breathing room, so shield the builders. The other says, if you profit from a powerful machine, you own its consequences. A British courtroom is about to pick a side, and the whole world is watching which one. Because whatever London decides won't stay in London. So what actually happens if this MP wins? Let's follow the dominoes, because they fall a long way. If a British court rules that xAI is legally responsible for what Grok generates, the comfortable era of the machine ends overnight. Suddenly, every AI company operating in the UK faces a terrifying new reality. They could be sued for any harmful image their tool produces, even one a user deliberately prompted. That changes the entire economics of the business. Right now, building a permissive image generator is cheap, and the legal risk feels distant. Make the company liable, and the calculation flips. The cost of a single major lawsuit could dwarf the revenue these features bring in. Picture an insurance company trying to price the risk of a tool that can generate literally anything. They'd run for the hills. The likely response? Guardrails everywhere. Companies would lock their image tools down hard, refusing anything involving real people, real brands, or anything legally radioactive. Grok's whole anything goes identity could become a liability rather than a feature. And this is where it gets surprising. If Britain establishes that AI firms are liable, other countries with similar legal traditions, Canada, Australia, much of Europe, could follow the precedent. One ruling in London could ripple across half the democratic world. But there's a flip side nobody likes to say out loud. Lock these tools down too hard, and you don't just stop the harm, you also kill legitimate creativity, satire, and art. The same filter that blocks a defamatory image blocks a harmless joke. That tension is the real story here. So while the courts grind through this, what can you actually do right now to protect yourself in a world where any image might be fake? Let's get practical, because this affects you, not just politicians. First, train your eye. AI-generated images still leave tells. Look closely at hands and fingers, where generators famously struggle, and count them if you can. Check the background for text that melts into gibberish, jewelry that merges into skin, or shadows falling in impossible directions. If something feels slightly off, trust that instinct. Second, reverse search before you believe. Take any shocking image, drop it into a reverse image search tool, and see where it actually came from. If a supposedly brand new photo has no credible source, treat it as suspect. Third, slow down before you share. The entire harm of a fake image depends on speed. It spreads fastest when people react emotionally and hit repost without thinking. A 5-second pause breaks that chain. Fourth, if a fake image of you or someone you know appears, document it immediately. Screenshot it, note the link, the date, and the account that posted it, then report it through the platform and, in serious cases, to the police. That evidence trail is exactly what makes legal action possible. And fifth, know your rights. In the UK, sharing certain fabricated intimate images is now a criminal offence under recent law. Other countries are passing similar rules fast. You have more protection than you think, but only if you act on it. Because the tools aren't slowing down, and neither should your awareness. So here's what this all means for you, and why this one lawsuit matters far beyond a single British politician. We are watching, in real time, the moment the law tries to catch up with the machine. For 2 years, AI image tools have lived in a grey zone, powerful enough to fabricate convincing lies, but shielded by rules written for a different era. This case in the United Kingdom is the first serious attempt to ask the question that decides everything. When the machine causes harm, who pays? If the MP wins, expect a wave of lockdown, cautious AI tools, and a global precedent that AI companies own what their products create. If xAI wins, the anything goes era gets a powerful green light, and the burden stays on you to spot the fakes. Either way, the comfortable pretense that AI-generated content has no author is dying. Someone, somewhere, is about to be held responsible, and the only question is who. Keep your eye on this one, because the verdict will quietly rewrite the rules for every image tool you'll ever use. The next deepfake you see might be harmless fun, or it might be the test case that changes the law. If this breakdown helped you see the bigger picture, follow for daily AI news. We track these stories every single day, so you're never blindsided by what's coming next. The future of who controls AI isn't being decided in a lab. It's being decided in a courtroom, and it's happening right now.